Good afternoon, everyone. My name is Baljinder Gill. I am the Community Training and Outreach Coordinator with Legal Aid BC. Before we start the session, I would like to begin by acknowledging that the land on which we gathered today is the traditional unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. On behalf of Law Foundation and Legal Aid BC, I welcome you all and the speakers of today's sessions, and also my special thanks to Sarah Chow and Alessia Mordini for providing us tech support. Without their help, we won't be able to do these sessions. We have two wonderful speakers today, Rob Patterson and Zuzana Modrovic. Rob is with TRAC from 2018, and he's been called to the bar about a week ago, as I remember. And Zuzana is also with TRAC from 2016. So please join me to welcome them both, Rob and Zuzana.
Thank you very much. Thanks for the introduction and for having us. We have, so today's presentation is all about getting some, I guess, practical experience, doing a sort of housing law case study. We've come up with some examples. So the rough structure of the presentation is first, we're going to talk about sort of the relevant principles and practices when a housing file comes across your desk, how to address it, how to identify the issues, do legal research, look up statute, and then we're going to, that'll be the first roughly half of the presentation. And then the second half, we have a fact pattern that we're all going to do, break out into breakout rooms and sort of turn those same skills that we talked about in the first half to talk about that. We will have opportunities for questions. We'll break after like individual sections, and you can ask questions if you have them. And then with the breakout rooms, Zen and I will be going around the different breakout rooms to chat with everybody. If you haven't had a chance to download that fact pattern already, it should be up on the SCED page for this session. So hopefully you have it. If you don't, it should be very quick to get. But further ado, I'm going to start sharing my presentation screen. All right. So let's get into this. So like I mentioned, we're going to sort of address sort of three general topics of how to prepare for a case or how to research for a housing law case, with issue spotting, statutory interpretation, and research. Then we're also going to, throughout the course of this, we're going to be talking about places you can go to engage in that kind of statutory interpretation and research. So the most important ones we sort of listed here. So the Residential Tenancy Act and its regulation are obviously very important. Of course, if it's a manufactured home park tenancy, it's the Manufactured Home Park Tenancy Act and regulation that are going to be the important pieces of statute. There are also, of course, the Residential Tenancy Branch has their own sorts of resources, the most important being the policy guidelines that they produce that aid parties in sort of interpreting the Act and the regulations. And there's also the RTB Rules of Procedure, which sort of talk about how hearings are conducted and the rules for dispute resolution in general. CanLII is also a crucial resource. It's a free online database of court decisions across Canada. It's a fantastic resource when doing any kind of research, in part because it doesn't cost anything to do, unlike many other legal research tools or platforms. And we're going to get into, we'll sort of talk about how to use these resources as we go through the presentation. So let's talk first about issue spotting. So when a case comes across your desk, when you speak with the client about their housing issue, from the very beginning of that interaction, it's really important to identify and begin to identify what the legal issues that are relevant to the case are. And when you're doing that, you're trying to figure out what are the client's concerns, and then how do they relate to what the actual legal issues are before you. When you identify the issues, you also have to figure out, what sections of the legislation and the regulations do they actually engage. So, if someone has been served a notice to end tenancy, for example, under what section of the Act have they been served? What does that section require? And then you also have to keep in mind as you're going through this, when talking with a client or figuring out more about a case, what else do you need to know about a case as you go through it? So, for example, if you see a tenant has got a 2-month notice to end tenancy for landlord use, a very common kind of eviction notice. You identify the section of the legislation that engages, and you can look at the different requirements. One of those requirements, for example, is that a person be a landlord as defined in that section. It's slightly different from the regular landlord definition. So that might prompt you to be, okay, well, I may not know whether this person who's issued this notice meets this definition. What more information do I need to get to be able to know whether this is a legal argument that's going to help me, that it's useful to make in a hearing. When you turn to statute, it's very important to know, how you can use statute to argue in a hearing, or even to just, at the first instance, know what a statute means or can mean in the hands of a good advocate before an arbitrator. So there is a modern approach to statutory interpretation, so to determining what a provision of a statute means. This quote here is directly from a Supreme Court of Canada case called Rizzo and Rizzo Shoes, which is sort of the big leading Supreme Court of Canada case on how you're supposed to read sections of an act. So the court said that the words of an act are to be read in their entire context and in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. And to sort of break that down into what each individual things mean. So the words are to be read in their entire context means that you can't sort of take a provision and pluck it out of context. You have to read it in context with what's around it. So if there's other provisions that sort of interlock, that when you read them together gives you a better idea of what it means, that's what you have to do. Grammatical and ordinary sense refers to the sort of dictionary definition of a word. So sometimes it'll be useful for a hearing to be able to refer to what the dictionary definition of, for example, occupy means. Interpretations also, again, have to be harmonious with the scheme of the act, the object of the act, and the intention of Parliament. So the scheme of the act is sort of what is the, in this case, we're talking usually about 2 acts. What is the Residential Tenancy Act trying to do? What is its purpose? How is it set up in its framework? And what is its object? What is the point of the act? And also the point in general of this particular provision of the act. And finally, intention of Parliament is, what does the people who, in the provincial legislature who wrote this, what did they mean for it to mean? Because of, so if you can find evidence about that, that can help you in some situations where the definition of certain statutory provisions may be up in the air or being argued over. Another important aspect of statutory interpretation comes from the Interpretation Act of BC, where Section 8 says every enactment, so enactments like legislation, that's both like Residential Tenancy Act, Manufactured Home Park Tenancy Act, and their regulations, must be construed as being remedial and must be given such fair, large, and liberal construction and interpretation as best ensures the attainment of its objects. So that first part, every enactment must be construed as being remedial. What it's saying in stilted language is that every part of an act and every part of the act is meant to do something, and you have to read it as though it's meant to do something, not simply to uphold the status quo, but actually to have a function. And second, any part of the act that's trying to do something has to be given a broad interpretation that best suits the goal that it's trying to accomplish. It's sort of in harmony with the section of the modern approach to statutory interpretation from the Supreme Court. You have to sort of identify, what is the point of this particular provision in the act, and what's the interpretation of it that best accomplishes the goal of that particular part of the act. So there has been case law, and that has found that the Residential Tenancy Act is primarily an act to protect tenants. In particular, sections about how tenancies can end are designed to effectively protect tenants and only allow their tenancies to be ended in particular situations, which can be used to argue, the fact that argue interpretations that sort of narrowly constrain the requirements for landlords. So they can't be sort of they can't be easily met, but have to be sort of specific to what the act says. So resources that you can turn to help you in interpreting Residential Tenancy Act provisions include policy guidelines of the Residential Tenancy Branch. You can turn to the Interpretation Act. It has Section 8 has that specific part, but other parts of the Interpretation Act will define commonly used words in all kinds of legislation, such as days, if you're trying to count days in a timeline, and also the common law. So common law refers to previous decisions by courts that are binding upon the Residential Tenancy Branch. So Residential Tenancy Branch decisions themselves aren't binding on future arbitrators. So if one arbitrator interprets a provision a particular way, another arbitrator doesn't have to interpret it the same way. But if a matter goes before the BC Supreme Court or the BC Court of Appeal, or even up to the Supreme Court of Canada, and one of those courts says this is how we interpret this part of the act, that is binding on Residential Tenancy Branch arbitrators. They don't have the discretion to ignore it. They have to address it in some fashion. It gets a bit more complicated when you talk about decisions from other jurisdictions. So, for example, a common law decision from a court in Ontario may be relevant, but it's still not binding in the same way. It's persuasive. So if you want to argue about what something means, a decision from another jurisdiction about what that provision means may be useful, but an arbitrator doesn't have to follow it. It's sort of similar to when you're putting past RTB decisions before them and saying, suggesting that they follow the same logic. It's not binding, but it can be persuasive. So when doing research, sort of where to go to find these sources. So statutes and regulations are hosted online. You can find them on the BC government website. I think in sort of listing what the important sources are right now as well, in addition to the Residential Tenancy Act and the Manufactured Home Park Tenancy Act and their regulations, there's also the COVID-19 Related Measures Act. That's an important act to read because it enacts a number of other COVID-related regulations, some of which apply to residential tenancy and manufactured home park tenancy. So those are all important statutes, again, all on the BC government website, and they're also actually hosted on CanLII. You can sort of pick which website you prefer. RTB policy guidelines and the rules of procedure are both hosted on the BC government website under the tenancy section. Tenancy policy guidelines are listed by number. And the rules of procedure are hosted on part of the website, and they typically also will host up the previous rules of procedure as well, one previous version, sometimes two, in case that becomes relevant for some reason. It happens every once in a while. Past RTB decisions can also be found. So the search box for that is at the bottom of the screen here. If you it's on, again, the BC government website, and you can do a keyword search through them. It's not a particularly robust search. It doesn't have a ton of features, but it can still be useful for looking for similar decisions. But again, it's important to remember that while they may be persuasive, they're not binding in the same way that relevant court decisions are. So if you can find a case from a court case that is specifically on point on a case of a point you're trying to argue in a hearing on a legal issue that comes up in one of your files, that's usually more effective and more useful. And one of the best ways to find that is through what's called noting up legislation. So I have some pictures here to illustrate it, but really the easiest way to do this is just for me to open up my CanLII itself on this page. So CanLII is a great resource, again, for finding these sources. This is the front page of CanLII. There's 3 possible searches you can do. Document text searches the text of any particular statute or case. And it's good for if you're already narrowed your search down a little bit, if you're trying to find specific cases that mention specific factors, like a pets clause or something like that. You can also search specifically by case name, document title, file number, author, or citation. This is the fastest way to get to the Residential Tenancy Act. And you can also, here's the line for noting up cases. So I'll show you a couple different ways to note up a section of the Act. So first, let's go to the Residential Tenancy Act. You want to make sure you select the one that's from BC. So it's SBC, the Statutes of British Columbia, 2002. And here is the Residential Tenancy Act. So every which section. Now let's say you have a jurisdiction issue. So you're looking at section 4 of the Residential Tenancy Act. Over here on the right side of the page, this little speech bubble with a 42 in it. you can click it open. It allows you to copy the text of this provision or to copy the citation to it. It also allows you to see what documents in CanLI's library cite this section of the Act. So if we click Citing Documents, it'll open up a whole page. These are all cases that cite Section 4 of the Residential Tenancy Act. And you'll see it's actually filled in up here already. So it's citing Residential Tenancy Act, Section 4. You can also refine these decisions further. So if we go, one thing you'll usually want to do is click over here to Cases. And so all jurisdictions, so if you don't want the one Manitoba decision that cited the Section 4 of the Residential Tenancy Act, you can just click British Columbia to refine it only to BC. You can also, this is the thing you definitely want to do, under all courts and tribunals, you probably want to click, almost always want to click all courts. So if I click all tribunals, you'll see these are all decisions of the BC Civil Resolution Tribunal, and these decisions, like RTV decisions, are not binding. So if you're looking for legal precedent to base your arguments on, much better to click all courts. These will get you court decisions from within British Columbia. So you see here BCCA in a citation means it's from the Court of Appeal, and BCSC means it's from Supreme Court. So Supreme Court is the court of first instance, and then parties can appeal from that to the Court of Appeal. So in theory, Court of Appeal decisions are the even stronger law, I guess. If there's a conflict, if a Court of Appeal and a Supreme Court conflict, Court of Appeal would take precedence. You can also sort by date to see what the newest decisions are. You can see that I have looked at a couple of these decisions myself recently, and then that allows you to sort of find relevant cases that might raise issues. If you want to, even once you get here as well, you can also search within these results by searching in the document text. So if I wanted to search health facility for the housing-based health facility situations, we can see there are two cases that specifically talk about, well, one case talks about health facilities here. This talks about health and facilities. So really, I should have put quotation marks around it, and then it would only turn up one. So you can use all of those Boolean search functions that you want when sort of refining your search this way. There's also another way directly to go to noting up legislation. Let's say you already know what section of the Act you want to look at. From the main page, you can go here to Residential Tenancy Act, put it in the third line, make sure SBC is selected, and then you can put in the second half of the line any section of the Act. You can scroll through and see what sections you can pick out of a hat, which is actually great for me because I didn't know which one I'd use. So let's just click Section 28, and we can see that there are 13 cases that deal with Section 28, of which there are 9 from courts and 3 from tribunals. You also get human rights decisions thrown in too. So another reason it's good to limit it only to court decisions. Because these are the ones that are binding and the most useful. Is there anything I'm missing on that, Zuzana? Anything we're not talking about? Any special feature of CanLI I've forgotten to mention?
I don't think so.
Okay. If one thing you can do also, if you're on CanLI a lot, this Lexbox line here, you can create an account with this service called Lexbox, and allows you to save decisions in a sort of library so you can recall them. You can also set up alerts. So if there's other decisions that come out later and might change the law, it'll send you emails. In addition to cases, there's also commentary. So there's not a ton of residential tenancy commentary up on CanLI, but it's a good feature to know about in case people write any. And this sort of points you to case summaries or journals or manuals that parties have written and end up uploaded onto CanLI. Another way to sort of figure out more, get a more fleshed out idea of how the law applies in a particular case. Okay, there's my CanLI going through CanLI. But before we get into some examples that Zuzana wants to roll through, are there any questions at this point about what we've talked about so far? Going 1 time, 2 times, 3 times. All right, I did it. I told you everything you need to know about research. So with that, Zuzana is going to run through some example situations, some example fact patterns. So here we go.
Okay, so while I'm going through these,
it may be useful for everyone to have the Residential Tenancy Act policy guideline page open, maybe the regulation as well. If you want to sort of follow along and try to do the act of issue spotting and figuring out what the sections are that are relevant. The first scenario is a short example about a tenant who comes to you with a 4-month notice to end tenancy for renovations. So if you've ever seen one of these, it usually just has some checkboxes and then a box that says, what is the work that you're planning, if you're planning to do renovations. So in the planned work section of the notice to end tenancy, the landlord has written that they plan to remove and replace all of the plumbing and electrical systems in the rental unit. The form also indicates that the landlord has an electrical permit, and the tenant has confirmed with the municipality that the landlord has a permit to remove and replace all electrical systems, but the municipality has told the tenant that there's been no other permits issued for the rental property. So the first question to ask always is, what are the legal issues and what the legislation, regulation, policy, or rules are engaged by those legal issues? If you're a fairly new advocate, you may have to actually look to the legislation before you know what the legal issues are, so it's fine if you do this in a different order from sort of what I do things in. But just for that reason, I think if we go to the next slide, I've sort of put the relevant sections of the RTA on this slide. So looking at the RTA will often help you figure out what the relevant sections or what the actual legal issues are that the tenant has. So here, the sections that I've pointed to, and there may be other sections that are sort of tangentially engaged. I've sort of picked out the sort of most important sections of the RTA that are triggered by this tenant situation. So the first section there is section 49.6, subsection B, which is that a landlord may end a tenancy if they have all of the permits and approvals that are required by law and intend in good faith to renovate the rental unit in a manner that requires the rental unit to be vacant. So there's also section 49.2B, that talks about sort of what the notice period has to be, and like at what point in the month does the notice have to be given to the tenant. Talks about what happens if the tenant's on the fixed term agreement versus a periodic one. Section 49.7 just says that a notice given under Section 49 has to comply with Section 52, which is the form and content of a notice to end tenancy. So it's something that, you know, especially if you haven't seen a lot of notices to end tenancy, you might want to look to that section to see what needs to be in there. And it's useful to know that there are actually prescribed forms for landlord's notice to end tenancy. Section 49.8B, tenant may dispute a notice given under subsection 6 by making an application. And this gives you the deadline for the tenant for how long they have to dispute the notice they've been given. And next slide. Okay, so after you've looked at the Act for a while, you may have had a sort of notion of what the legal issues are before, but after you have, you can sort of boil those down and break them up into sections. So the main legal issues, well, first, the tenant has a form of notice to end tenancy. That's sort of the big problem that the tenant is facing. And if you've looked at section 49.6b, you know that there's sort of 3 elements to figuring out whether or not the notice, whether or not you have grounds to challenge the notice. So the first thing that is required of a landlord before they can issue this kind of notice is that they have to have all of the permits that are required by law to do the work. To do the work that requires the unit to be vacant is something that we'll get to a little bit later. The next thing that it requires is the work that the landlord's planning to do has to be such that it sort of objectively requires the unit to be vacant. So you need to figure out whether that's the case. And third, it requires the landlord to have issued the notice to end tenancy in good faith. So those are sort of the 3 elements that you can pick out by looking at section 49.6b itself. Next question asks what section of the legislation, regulation, policy, or rules are engaged. Well, those are the ones that we sort of looked at in the last slide, along with policy guideline 2B. So if you have the page with the RTB policy guidelines open right now, you can sort of look at a list of policy guidelines and quickly pick out that policy guideline 2B has to do with a landlord's notice for renovations or demolition. So the third question, this is sort of a question that you have to ask yourself at almost every step of the process. Is there anything that you don't know yet that you've now identified that you need to know? Well, because you've looked at those sections of the Act, you realize that you need to know when the tenant received the notice, because you found out now that the tenant has up to 30 days from the day they received the notice to dispute it. You need to know whether the tenant has already filed to dispute the notice. And if they haven't, you need to know if they want to. Is their goal to stay in the unit? If so, then they probably do want to. If their goal is to not stay in the unit forever, but maybe get an extra month or two to move, it's possible they don't have to file for dispute resolution. It's possible they'll be able to negotiate before they do that. But it is important that they meet their deadline. So you must know when they receive the notice and calculate when their filing deadline is from that. You need to know if the tenancy agreement is a fixed term, and if so, when does it end? Because you saw the section of the Residential Tenancy Act in the previous slide that said, essentially, if a landlord gives a 4-month notice to end a tenancy that's a fixed term tenancy, it can't take effect until the end of the fixed term. They're not allowed to sort of end the fixed term tenancy early by issuing this kind of notice. And lastly, you need to know whether there's a reason to question the landlord's good faith intent to perform the renovations, because you've now found out that Section 49, subsection 6B of the Act requires the landlord to have a good faith intent to do the work that they say they're going to do. And here, so we're moving on to statutory interpretation. So once you flag the issues, you need to know what part of the statute that you've seen is engaged actually needs some interpretation or has room for interpretation. So in 49.2b, 49.7, 49.8b, those are all fairly straightforward, and I don't really think there's a lot of room, at least not in this fact example, to argue about interpretation of those. But 49 subsection 6b, 6b has a fair amount of interpretation to be done in it. So you first need to know what it means for a landlord to have all the necessary permits and approvals required by law. You need to know what good faith means. What does it mean for the landlord to intend in good faith to do the thing that they say they're going to do, to renovate the rental unit in a manner that requires the rental unit to be vacant? And thirdly, you need to know what it actually means for the work to require the rental unit to be vacant. And sort of those are the major things that need interpreting here. So first, generally when I'm looking at a piece of the RTA, a term in the RTA, and I want to know how to interpret that section, I first look to see if there's any policy guidelines that help me in interpreting that before I move on to any other sources, because the purpose of policy guidelines are to assist arbitrators and litigants to interpret the statute. That's their whole reason for being. And I quickly find out that there is a policy guideline that deals with, is it 2A? Did I mistype? Is it 2A or 2B? Yeah, it's 2B. I mistyped. So it should be policy guideline 2B that talks about permits and approvals required by law. And this quote is actually taken pretty much word for word from a BC Court of Appeal case, I think, that we'll talk about maybe a little bit later. So permits and approvals required by law. So it's a longer section than what is reproduced here, but this is sort of the crux of that section. The permits and approvals that are in place at the time that the notice to end tenancy is given must cover an extent and nature of work that objectively requires vacancy of the rental unit. The onus is on the landlord to establish evidence that the planned work which requires ending the tenancy is allowed by all relevant statutes and policies at the time that the notice to end tenancy was issued. So once you've gone to policy guideline 2B and you've read the entire section on permits and approvals, you are going to have to ask yourselves a couple of questions. So does the landlord in this example have all the permits and approvals required by law? Well, if you recall, the landlord indicated in the notice that they have the electrical permit, that they need to remove all of the electrical systems. But in the notice to end tenancy, they also say that they intend to remove and replace all of the plumbing systems in the unit, but they only have an electrical permit. So that's a very important question that you have to answer. And in order to answer that question, you kind of need to know whether the electrical work alone is work that by its nature would require the unit to be vacant. Because if it would, it's possible that the landlord does have all the permits that they need to issue a section 49.6b notice. But if what the landlord is saying is that I need the unit to be vacant in order to do electrical and plumbing, and the reason I need it to be vacant is because I'm doing both of these things at the same time, then it's possible that you can argue that they don't have all the permits that they require by law because they haven't got their plumbing permit yet. Okay, so that's permits and approvals required by law. Next, we move on to good faith, because as we remember, and all of this should say policy guideline 2B, as we remember, the landlord must have a good faith intent to do the work that they say they're going to do in the notice to end tenancy. Policy guideline 2B has a section on what that means. It is longer than, again, it's longer than what is reproduced here, but I've sort of pulled out what I thought was the most cogent part of that section in that policy guideline. And to explain what good faith means, they actually quote almost directly again from some common law cases. So they say in Gaturo and Palmar Properties, the BC Supreme Court found that a claim of good faith requires honest intention with no ulterior motive. When the issue of ulterior motive for an eviction notice is raised, the onus is on the landlord to establish they are acting in good faith. And that comes from Bauman and ARD Investments from the BC Supreme Court level decision. Good faith means a landlord is acting honestly and they intend to do what they say they are going to do. It means they do not intend to defraud or deceive the tenant, that they do not have an ulterior motive for ending the tenancy, and that they are not trying to avoid obligations under the RTA and MHBTA or the tenancy agreement. Okay, so once you've figured out what good faith means, you have to ask yourself, do I have a reason to think that the landlord here isn't acting in good faith? And if I don't really know, what information do I need to know in order to sort of make that determination, whether there's a good faith argument to be made or not? So if the tenant sort of didn't give us any indication about why they think the landlord is doing this, perhaps the landlord the tenant has an idea of why the landlord is doing this, and that reason is other than the landlord just wants to do this work. Maybe there's been sort of a history of disagreements between the landlord and tenant. Maybe the landlord has tried to evict the tenant in the past with different kinds of eviction notices and has been unsuccessful. And this is just, the X number in a string of eviction notices. And all of those things would be relevant to figuring out whether you have a good faith argument to be made. And the only way you know this, again, is by interpreting the good faith portion of the section 49.6b requirement. Okay, so once you've dealt with good faith, you then move on to what does it mean for a landlord, for the work itself to require the unit to be vacant. So again, we turn to policy guideline 2B. Vacancy requirement is the heading of the section that you're looking at. And here they cite another case called Berry and Clowett, which is we use in almost every case that we have that involves Section 49. In that case, the BC Supreme Court found that the renovations by their nature must be so extensive as to require the rental unit to be vacant in order for them to be carried out. And the court found that vacant means empty, totally empty. It doesn't mean that the tenant can't be there but can leave their stuff there. It means it has to be, the tenant must actually have to move their stuff out in order for the renovations to be carried out. The court also found that it would be irrational to believe that a landlord could end a tenancy for renovations or repairs if a very brief period of vacancy was required, and the tenant was willing to move out for the duration of the renovations or repairs. So what that means is that if the tenant is willing to move, so if the landlord's saying, hey, I need to do this work requires all of the tenant's stuff to be gone, but it's only going to take a day or two, and the tenant is willing to move all their stuff out for a day or two and then come back, then that's a very relevant factor. So this is what the policy guideline tells us about the vacancy requirement. It also talks about a more recent case. So this is the ARD investment endowment case. That's the BC Court of Appeal level now. The Court of Appeal held that the question posed by the Act is whether the renovations or repairs objectively are such that they reasonably require vacant possession. Where the vacancy required is for an extended period of time, according to the Court of Appeal, the tenant's willingness to move out and return to the unit later is not sufficient evidence to establish objectively whether vacancy of the rental unit is required. So prior to this BC Court of Appeal decision, advocates were successfully arguing, even in cases where the renovations would take weeks or even months, where if the tenant was willing to move out and come back, then the tenancy can't be ended. And they were sort of using the Supreme Court level version of Bauman along with Berry and Clowett to make that argument. Now, BC Court of Appeal has sort of changed the interpretation of what it means to require the unit to be vacant a little bit by saying that if it needs to be vacant for a longer period of time, then it doesn't really matter if the tenant's willing to move out, move back in. So now you need to ask, does the work that this landlord wants to do require the unit to be vacant? And if you don't know, what else do you need to know? So you kind of need to know, well, how long does the landlord say the work is going to take? If the eviction notice doesn't say that, you might want to take steps to find out. Maybe you could ask the landlord. Sometimes they're forthcoming about that kind of thing. If you have any sort of experts in the field that have done this kind of thing and could tell you how long they think it should take, then perhaps you could do that. But you need to essentially know, that's an important piece of information to know to see whether or not this example would satisfy the vacancy requirement in section 49(6)(b). You might want to find out whether the tenant, so once you find out how long they should take, you might want to find out if the tenant is willing to move out, move back in. And that, together with how long it's going to take, should inform yours and an arbitrator's interpretation of what it means for the renovations to require the unit to be vacant. And lastly, once you've gone through all of the policy guidelines, if you want to do a little bit of case law research, if you don't think you have enough from the policy guidelines, you can do what Rob showed you how to do, and that is sort of search CanLII, note up the Residential Tenancy Act, and find out what cases cite section 49, as I've done here in the slide. Yeah. Okay, so the next example, maybe I'll try to go a little bit slower to give you time to work along with me if that's what you want to do. Because I should warn you that after we go through these, there's 3 examples, and then after we do that, we're going to give you all a fact pattern that hopefully you've downloaded already, and we're going to ask you to go into breakout rooms and do this work sort of together in your groups. So, short example 2. A tenant has asked for your help resolving a problem with their nonprofit landlord's guest policy. The landlord has implemented a policy requiring all guests to sign in and out at the front desk when visiting and to show identification. That guest policy is also a term in the tenancy agreement. The tenant says that when they tried to talk to the landlord about it, the landlord told the tenant that the RTA does not apply because the housing is transitional and because it is a housing-based health facility. So the first thing you got to do, as always, is identify the issues and what sections of the legislation, regulation, etc. are engaged by those issues. And then once you've done that, you have to figure out whether there's information missing from what the tenants told you that you need to know to go any further. Okay, so if you don't sort of off the top of your head know what the issues are, you can turn to the Act and take a look. First section that you're probably going to want to look to is the jurisdiction section, the section of the Act that says what the Act does not apply to. And you will notice that Section 4, subsection F, says that the Act does not apply to living accommodation provided for emergency shelter or transitional housing. And subsection G, subsection V, I guess 5, Roman numeral 5, living accommodation in a housing-based health facility that provides hospitality, support services, and personal health care is also not covered by the RTA. You'll also note that the next section, section 5, says that landlords and tenants may not avoid or contract out of the Act or the regulation, and that any attempt to do that is of no effect. And lastly, you can look to RTA Section 30 and see that a landlord must not unreasonably restrict access to residential property by a tenant of a rental unit that is part of the residential property, or a person permitted on the residential property of that tenant, by which we mean a tenant's guest. There's also the Residential Tenancy Regulation, which after you've looked at the Act, you might take a look to see if there's anything there that might be relevant. So the regulation in this case actually does give us a definition for transitional housing, which might be useful. So it tells us that transitional housing means accommodation that's provided on a temporary basis by a person or organization that receives funding from a local government or the government of British Columbia or of Canada for the purpose of providing that accommodation. And it's provided together with programs intended to assist tenants to become better able to live independently. And that is how the Residential Tenancy Regulation defines transitional housing. You might also look to regulation schedule, section 9 of the schedule. That's where all of the prescribed terms of every tenancy agreement are, and it talks about the landlord not being allowed to stop the tenant from having guests under reasonable circumstances. So all of those things are sort of engaged by the things that the tenant has told you they want help with. So once you've sort of looked at that, you start making your notes and you're figuring out what the legal issues are and how you might break them up. So you'll note the first section that you found, or the first issue that you found was jurisdiction. You don't really know if it's jurisdiction. You know that if there's jurisdiction, you know the landlord says there's not. But that doesn't mean there's not. Landlords often say a thing about the law that isn't correct. And in this case, you probably need to do the work to figure out whether the landlord is right or wrong about whether the RTB has jurisdiction. So sub-issues under the jurisdiction issue. 1, is it transitional housing? 2, is it a housing-based health facility as contemplated by Section 4 of the RTA? Once you've sort of gone through the jurisdiction or figured out what all the sub-issues of the jurisdiction issue are, you move on to the guest policy. That's sort of the substantive issue that the tenant has come to you for help with. Is the ID policy an unreasonable restriction on guests, I think, is what it boils down to. Then you ask yourself what sections of the legislation, regulation, policy, etc. are engaged. We've already seen the sections 30, section 4, section 5, 30 of the RTA, and then section 1 of the RTR, and then section 9 of the schedule of the RTR. But there's also policy guideline 46, which is a policy guideline on emergency shelter, transitional housing, and supportive housing that you might want to look to. And then you have to ask yourself, well, given what I know now, and now that I've identified the issues, I've looked at the Act and the regulation, what else do I need to know? If there's a written tenancy agreement, you may want to see it. You might want to see whether it says that that it's not a tenancy agreement, that it's an occupancy agreement, whether it cites the Residential Tenancy Act. We've seen several examples with landlords who say, this is not, the RTB has no jurisdiction because it's transitional housing or whatever. And then we look at the actual tenancy agreement they have with the tenant, and it refers to the Residential Tenancy Act throughout. So, you might want to see the written tenancy agreement if it exists. In order to figure out whether it's a transitional, whether the housing's transitional, you may want to know how long it has lasted so far. Because if the tenant's been living there for 10 years, it looks a lot less transitional than if they've only been there for a few months. And what's the tenant's understanding of how long they're allowed to stay there? Because even if they're only been there, for a few months or a year, if they were told that it was indefinite, if their understanding it was that they could stay there forever, that's going to be relevant to the determination of whether or not it's transitional housing. You want to know whether the landlord sort of talked to the tenant about a plan to transition to other housing. You might want to know what kind of services the landlord provides other than sort of the normal housing service. You want to know if all of the tenants in that residential property have specific healthcare needs, because you know that the landlord has also claimed that this is a housing-based health facility. And then one thing you may want to find out is whether the guest ID policy applies to all tenants or just some of them. And the reason you ask this question will become clear a little bit later on. Okay, so once you've done this, you've spotted the issues, you've sort of broken them up, you've seen the sections of the Act, you now need to figure out what you need to interpret. Of what you've seen, what do you need to interpret? So I've highlighted again the things that I think need to be interpreted in the sections that are engaged by this problem. First, you need to know what it means for something to be transitional housing, because that's what the landlord is saying this is. You need to know what it means for something to be a housing-based health facility that provides hospitality support services and personal health care, because the landlord says that it is also that. You need to know what it means for a landlord to unreasonably restrict access to a residential property. And if you're sort of pulling in the Section 9 of the schedule of the regulation, then you need to know what the landlord, like what it means for the landlord to not be allowed to stop tenants from having guests in reasonable circumstances. Like what does the reasonable circumstances bit of this mean? I think basically the reasonable circumstances and the bit of the schedule in the regulation and the unreasonably restrict in Section 31 is basically amounts to the same thing. So if you interpret one, you've probably interpreted both. So first thing we identify we need to interpret is transitional housing, but we already know, because we've looked at the regulation, that we don't have to look too far for that, because we have a definition in the regulation itself. So the regulation tells us that this is what transitional housing means. I've already sort of read this out, so I'm not going to do that again. So you need to answer these questions. Is it temporary? Is it provided by a person that receives funding from a government level, essentially, to provide that accommodation? And is it provided together with programs that are intended to help the tenant to transition to sort of more independent living? You then also remember that there's a policy guideline 46, that right in the title says transitional housing. So you may want to go there to look at what it says about what transitional housing means. And this is what it says. It says that transitional housing is intended to include at least a general plan as to how the person residing in this type of housing will transition to more permanent accommodation. It says individuals in transitional housing may have a more moderate need for support services and may transition to supportive housing or to independent living. Residents may be required to sign a transitional housing agreement. Living accommodation must meet all of the criteria in the definition of transitional housing under Section 1 of the regulation in order to be excluded from the Act, even if a transitional housing agreement has been signed. So this reinforces the idea that just because the landlord says something, something is transitional doesn't mean that it is. It actually needs to meet the definition in the regulation. And you can also look to case law to see how Section 4G should be interpreted. So the way that I did that, so we've done sort of the work for transitional. We kind of know what it means for something to be transitional, but we still need to know what it means for something to be a health facility. And unfortunately, Policy Guideline 46 doesn't help us with that. And there's no definition in the regulation or anywhere else for what it means for something to be a housing-based health facility, et cetera, et cetera. So we got to at least try to look elsewhere. So we look to Canley. When you do this, like Rob did when he was showing you how to research in Canley, you find really quickly that there's only one case that talks about it. So you find PHS Community Services in Swate and see whether you can pull anything useful out of that case about arguing whether or not this particular housing is a housing-based health facility. You may find that Swate is not enough. Now, we talked a little bit about how BC Supreme Court and Court of Appeal and Supreme Court of Canada decisions are all binding on the residential tenancy branch. But sometimes you just can't find things that are on point, or you just don't find enough things to help you make the interpretation arguments you want to make. You can still look to past residential tenancy branch decisions. An arbitrator may rightly tell you that they are not binding, but you can argue that they should at least be persuasive. So you can do a little bit of research on the Residential Tenancy Branch website, look through past decisions to see how past arbitrators have interpreted housing-based health facility, and then pick the ones that that fit the best to your facts and make arguments that similar reasons should be used in your case.
Okay.
And I think Rob's going to take over and do short example 3.
That's correct. All right. So, short example 3. A tenant has filed their own application with the Residential Tenancy Branch to dispute a 1-month notice to end tenancy. They come to you on October 27th. They received the notice on September 1st, and they filed online on September 7th. The tenant's hearing has been scheduled for November 10th. And the tenant's hearing has been, the hearing has been November 10th, and they sent their evidence to their landlord by registered mail on October 23rd. So what are the legal issues? I actually, as I'm reading this, if I recall correctly, that 1-month notice should actually read 10-day notice to end tenancy in order to make this a more interesting question. So pretend that says a 10-day notice to end tenancy for non-payment. But they sent the landlord their registered mail on October 23rd. So they come to you because they're concerned about their deadline. So what are the legal issues? What sections of the legislation, regulation, policy, or rules are engaged? And what else do you need to know? So what are the legal issues? First, the question is, did they file to dispute the notice to end tenancy on time? That's the first key question. And second, what was the deadline for serving their evidence to the hearing? Did they serve it in time? And if they did, what should they do to prove that? If not, can they do anything now? So what sections of statute policy are engaged? Sections 88 and 90 of the Residential Tenancy Act are engaged. The rules of procedure are engaged as it regards to service and specifically to definitions of days. Policy guideline number 12 talks about service of documents. And what else do you need to know? You probably need to know what proof the tenant has of when things were actually received by the other side. But let's sort of look at what the rules say about these things, about how to serve in general. Actually, maybe I'll take back a step and talk about, so when we're talking about did the tenant file on time, what you have to do with any kind of eviction notice is to first, it's good to look back at the legislation when you get a notice and see what the requirements are. With a 10-day notice to end tenancy, a tenant has to file within 5 days of receiving it. Again, and with for service for the hearing, for serving evidence before a hearing, it's not actually the act, but it'll be the rules of procedure that say that a tenant has to, an applicant, in this case a tenant who applies to dismiss an eviction notice is an applicant, has to serve all of their evidence has to be received by the other side at least 14 clear days before the hearing. So those are sort of the two timelines we're playing with. 5 days to file to dispute a 10-day notice, and 14 clear days before a hearing that evidence has to be received by the other side. Then the question is, that's not enough. It's a question of what are the rules about when something is received and about how time passes. So first, in terms of evidence, the tenant sent it by registered mail. What does that mean? So Section 88 says how to give and serve documents generally. This is from the Residential Tenancy Act. So for documents other than those referred to in Section 89, and I'll tell you now, Section 89 does not say evidence for a hearing. They can be sent by, there's a lot of letters, but C is sending a copy by ordinary mail or registered mail to the address at which the person resides, or if the person is a landlord, to the address at which the person carries on a business as a landlord. So that's how to send it, but when when is the law consider it received? Section 90 is what we call the deemed receipt provision of the Residential Tenancy Act. So if a document is given or received in accordance with Section 88 as above, or 89, unless earlier received, is deemed to be received as follows. So the important one here is A, if given or served by mail on the 5th day after it is mailed. So if we look back to our example here, the tenant has actually filed served if they're deemed received 5 days after service, they've actually served late. When we apply that rule to that. But what does it mean? What does deeming mean? What does unless earlier received mean? How does that apply to the situation? Then we can turn to policy. So policy guideline 12 is about service provisions and talks both about deemed receipt and about proof of service. So if we're talking, it's all fair and good to say what the rules are. You also have to prove that you followed them, especially when it comes to service. Section 11 of Policy Guideline 12 talks about deemed receipt, sort of summarizes how the Act applies in the first few paragraphs here. And then at the bottom 2 paragraphs there, you see deemed receipt provisions are generally used in the absence of evidence of the date documents were actually received, such as when a respondent has not filed for a dispute or appeared at a dispute resolution hearing. The provisions are also used to calculate timelines for future events, such as when notice of hearing packages must be served in order to ensure the respondent has a required amount of notice for the hearing. Deemed receipt provisions apply when there is no evidence of actual receipt, in the absence of evidence. So if you have evidence of when it actually was served, that can be used to get around that deemed receipt provision if it's going to deem it received too late. So then the question is, how do you prove it? Under Section 15 of Policy Guideline 12, you can see at the bottom there, we know it was sent by registered mail. So it says proof of service by registered mail should include the original Canada Post registered mail receipt containing the date of service, address of service, and that the address of service was the person's residence at the time of service, or the landlord's place of conducting business as a landlord, as well as a copy of the printed tracking report. So the tracking report for registered mail should show the day on which the mail was actually received. If the tenant and landlord are live in a close to each other, if the mail didn't have to go very far, and at least in more normal times, mail does not take very long. Registered mail often will be received before the 5-day deadline. But I think now these days it might be a bit tricky to count on that. But if you have proof that it did indeed arrive before the deemed receipt said it arrived, then that's certainly very valuable. Now, in terms of how are we counting days here, that's also very important. In particular, I want to highlight this definition of days as it applies to the whether or not we have solved the question of whether the tenant filed to dispute in time. So if you look at any section of the Act that deals with landlord's notices to end tenancy, you'll see that if a tenant does not file within their time period, they are conclusively deemed to have accepted the end of a tenancy. And it's very hard to get around a conclusive deeming provision. So one thing you might want to see is on whether the tenant applied. You need to find out whether the tenant applied for more time when they made their application. But you also want to see, what do the rules say about how days are counted? So here you can see if a time for doing an act in relation to a dispute resolution proceeding falls or expires on a holiday, the time is extended to the next day that is not a holiday. And B, if the time for doing an act in a government office, such as the Residential Tenancy Branch or Service BC, falls or expires on a day when the office is not open during regular business hours, the time is extended to the next day that the office is open. And this definition applies whether or not an act can be carried out using an online service. That has been added to remove uncertainty about the online application process, because in theory, you can apply on a holiday, an online application, but that doesn't actually stop if your deadline is on a holiday or on a day, if you're doing it in a government office, if it expires on a day it's not open during regular business hours, it extends to the next day the office is open. Just because the website's up doesn't mean that clock doesn't get held by beat. So now if we go to the calendar, we see that, recall that the tenant received the notice on the 1st and filed on the 7th of September. You can see that the 6th was a Sunday. So that's great news for the tenant because the rules of the days there, because they had to file in the government office, even though they could do it online, because the office is closed on Sunday, the deadline falls to the Monday. So they actually did file in time, and you don't have to worry about coming up with all kinds of arguments that you can for trying to argue that the deadline, the time limit for filing should be extended, because there aren't that many great arguments. The standard is very high. Then there's the question of, did the tenant serve their evidence in time? And if we recall back, just let me pull up my notes here to remind myself of the days. The hearing is on November 10th, as you can see, right? I think I have a pointer, November 10th, as you can see right here. And they sent their evidence in the mail on the 23rd. So if we take the 23rd and we add 5 days, 1, 2, 3, 4, 5, that's the 28th. That's when the landlord will be deemed to have received it. If we go on the 10th, we don't count the 10th, you count 14 days back. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. We see that it is, unfortunately, significantly behind when they were supposed, sorry, it doesn't count that either. They have been served too late. They served their evidence too late. So you'd have to have evidence that the landlord had received the evidence at least by the 27th. In order to, so if you have registered mail showing that, great. If not, then you have a whole other set of research to do about how to deal with late evidence and how the residential tenancy branch deals with that. The rules of procedure have their own sections on that, but we don't know if you have to do that until you check with the tenant to see what their registered mail receipt actually shows in terms of when it actually was received by the landlord. Are there any questions about for example 3? Once, twice, 3 times. All right. So now we're on to the full big fact pattern. Hopefully everyone's had a chance now to download it or to open the packages under your chairs if you're sitting in the Radisson somehow. I'm not sure you could be. But the PDF is available on Sched. It's 1 page of text and then some attached tenancy agreement and notices to end tenancy. So I think this is a good time for to speak into the void and ask the Zoom gods and Law Foundation handlers of those said Zoom gods to maybe do a breakout room kind of scenario where we can hopefully you can get together in small groups. You can talk about the fact pattern, and what we would like you to do is the same process that we went through when we went through these sample fact patterns. Someone has entered the waiting room. Go through the same process when we talked about these short examples. So to go through and say, identify the legal issues, identify, do some statutory looking to see what statute, what regulation, what rules are going to apply to the situation, and then use research tools, so looking up the statute, looking up the rules, looking at the policy, and looking at relevant case law to see what arguments might be available to the tenant in the situation that the fact pattern describes, what you'd recommend they do. They have, I'll give you, I guess, a little bit of a hint. There are 3 legal issues before them. 2 of them are eviction notices, and the 3rd you'll figure out because it says at the end. But yeah, I think we'll give you maybe we have about 50 minutes left in the time for this presentation, so we'll give maybe 10 minutes, 10 to 15 minutes for everyone in their breakout groups to read through the material.